Okay, so I am going to do a bit of a case law update. So most of these cases are BC Supreme Court cases. There's one Court of Appeal case in here. Just a reminder, when we're dealing with court cases are binding on the RTB. Our other RTB decisions are not binding, they're persuasive, but court cases are binding on the RTB, so the RTB does have to follow court cases. So the first case I want to discuss, it's a bit of an old case, but I thought we could maybe have a bit of a refresher on the Baumann case because we're going to talk about the Court of Appeal case as well. So I'm sure you're probably all familiar with the Baumann and Aarti Investments case. So this was a 2018 case. Whenever we're dealing with the renoviction issue, the legal test that is going to be applied is threefold. So whether or not the renovations or repairs require that the unit be vacant for those repairs or renovations to be completed, whether or not the landlord has a good faith intention to renovate or repair the unit, and whether or not the landlord has all the permits and approvals to undertake those permits or repairs. So in regards to vacant possession, in the Baumann case, the court found the following. Court found that the arbitrator failed to consider Ms. Baumann's offer to vacate the rental unit for the duration of the repairs. And I should note here that the duration of the repairs were quite lengthy. I think it was months. It was not short-term duration. It was very long. Judge goes on to say that the rationale behind Section 49, subsection 6 of the RTA is to ensure landlords can carry out renovations. Terminating a tenancy where the tenant is agreeable to vacating for the duration of the renovations is inconsistent with this rationale. We were pretty happy with this, with this decision and this idea that an RTB arbitrator should consider whether or not a tenant is offering to vacate for the duration of the renovations or repairs, because that would be very good for our clients who are tenants. So that was pretty exciting when we got this decision and we saw that conclusion in regards to the vacant requirement. In terms of the good faith requirement, court found that the arbitrator fell into error and neglected to properly apply the burden of proof on the landlord to establish good faith. So the arbitrator in this case basically put it on the tenant to establish that the landlord was not acting in good faith, when we know the onus is on the landlord. So the court did find that the RTB arbitrator did shift the onus and reverse it. And the court also found that the evidence and context was more than sufficient to raise the issue of good faith. The arbitrator failed to properly come to terms with the requirement to address the issue of good faith. There was a transcript that, for those of you who've read the decision, that basically had a landlord's representative. It's unclear what this person's role was, but this person definitely seemed to be making a representation on behalf of the landlord, and there was a transcript of this conversation between this representative of the landlord and the tenants, and it's very clear in the transcript that this representative was almost trying to bully tenants into just agreeing to move out. I think some buyouts were offered, but it was very clear in the transcript that there was evidence that the landlord might be acting in bad faith. So the judge in this case said that was enough. That was enough to raise the issue of whether or not there was an ulterior motive. So, and then went on to determine that because that ulterior motive issue was raised, looked at how the arbitrator dealt with the good faith requirement and found that the burden did shift. In regards to permits, the court found that the landlord did not have all the necessary permits for the work to be carried out, and they went on to say that the requirement for all necessary permits is not satisfied by obtaining some of the necessary permits. I believe it was the electrical permit, wasn't complete. The electrician in the hearing even said it needs an update. So it wasn't a fully completed permit, and so the judge here found that that does not mean you have the permit if you only have part of the permit or it's incomplete. So generally pretty good decision. I think most people were happy when they saw this decision. Unfortunately, that changed a bit because then we have the Court of Appeal case that came down recently. And I should note that the RTB was very quick to entrench this decision in policy, which was interesting because they then had to go back and fix. I'm not sure what exactly they entrenched in the decision, but I do know there were some things in the BC Supreme Court level that they then put into policy. And just a note to policy makers everywhere, just wait before you entrench case law into your policies. Because, of course, the landlord was dissatisfied with that decision and appealed. So, case goes on to the Court of Appeal. And the panel, the BC Court of Appeal panel, unfortunately disagreed with the Chambers judge on the vacant possession issue. The panel found that neither precedent nor common sense required the arbitrator to expressly deal with the evidence that the tenant in this case was willing to find alternate accommodations for the duration of the work. So, I mean, this was a disappointment. This kind of overturned what the BC Supreme Court judge found. Although it remains to be seen whether or not, as Susanna pointed out earlier, what is the duration? Because Berry and Cloet is the case that dealt with the issue of vacant possession initially, and Berry and Cloet talks about when tenants are offering to vacate. And in Berry and Cloet, I believe that was a very short-term situation where the repairs and renovations were going to be done in, I don't even know if that it was a couple days. It was very short-term. So in that case, the judge did find that, yes, you do need to consider the offer to move when it's such a short-term duration. But of course, what seems to turn in the Baumann case is duration, really. The panel ultimately found that, it doesn't make sense that any tenant can offer to vacate for any duration and then be able to come back. And I think part of that might also have something to do with, at that time, the right of first refusal was also being introduced. So one of the arguments that the Landlords Council has was that it actually would conflict with the right of first refusal, because if any tenant can say, hey, I'm going to move out and move back in when it's done, then that sort of allows the situation for landlords to return after renovations at the same rent, which is what we know landlords don't want and what they've been lobbying for, and what the right of first refusal kind of allows landlords to do to start a new tenancy. So I think that was part of it. Of course, judges aren't supposed to act politically, but that was part of the argument brought forward by the landlord, and you do wonder how much that also may have been influential to the panel. Whoops. Okay, the good faith requirement. So generally the panel was in agreement with the Chambers judge in regards to the good faith requirement and the permits as well. Panel agreed with the Chambers judge that while the arbitrator found that the landlord truly intended to do the renovations described in the evidence, he did not expressly address the tenant's evidence of an ulterior motive. That was largely ignored, and the arbitrator had erroneously required the tenant to provide the landlord acted in bad faith. Again, we know the onus is not on the tenant, on the landlord, so panel did agree with the Chambers judge on that, and similarly agreed with the Chambers judge on permits, and found that the landlord had the permits and approvals acquired by law to do some, but not all of the work it contemplated. Panel went on to say that an arbitrator cannot waive or ignore the statutory requirement by issuing an order of possession if the landlord is not authorized and permitted to conduct work that will necessitate obtaining vacant possession at the time they issue the notice to end tenancy, which is also very important. Those permits have to be in place before the landlord even issues the notice to end tenancy. Okay, so that's Baumann. Bit of a disappointing decision, because I think we got some good stuff in regards to permits and good faith, but I think everyone was really upset to lose that vacant possession gain from the Chambers judge decision. Okay, the next case I want to talk about is MBB and Affordable Housing Charitable Society. So this is a case where the tenant was not able to attend the hearing, and this was due to both a language barrier as well as some medication that the tenant had taken prior to the hearing. So the original decision as well as the RTB review consideration decision were both judicially reviewed. In terms of the review division decision, the arbitrator in that decision, just to give you a bit more of the facts here. So the tenant, because of the language barrier and because of the medication, she didn't call into the hearing. She thought that the hearing would call her. She thought she would get a phone call, and then she would, and this is not uncommon. I don't know how any of you how much you encounter this, but I find oftentimes tenants will think that they're expecting a call rather than thinking they're going to be making the call. So this was one of those cases. And then on the review, in the review decision, the arbitrator basically said, well, if you knew you didn't understand the instructions of the hearing itself, the hearing instructions, you should have sought clarification. You should have called the RTB. You should have found out what you needed to do. But on review, Tenant argued in this case that there's a difference between misunderstanding and not knowing what to do, because she thought she knew what she needed to do. So seeking clarification would have been pointless. She was, as far as she knew, she had to wait for this hearing to commence. They were going to call her. So it wasn't an issue of her not knowing what to do. She just misunderstood what she needed to do. And so the court did find that the arbitrator's assertion that MBB should have sought clarification in advance of the hearing was not the answer. MBB did not assert she was confused. Rather, she thought she knew what to do. So it was unreasonable for the arbitrator to have this expectation that she should have sought clarification on the instructions, because it wasn't an issue of confusing the instructions. It was misunderstanding them, and there is that difference. So in terms of the original decision, this was the decision that just dealt with the arbitrator's finding that the tenant did not attend the hearing and used that as a basis to grant the landlord an order of possession. So I'm sure we've all seen this situation. Tenant doesn't call in, arbitrator says they're going to leave the line open for 10 minutes, no one calls in, arbitrator is issuing a decision that same day. Usually that decision says something like, oh, you didn't attend the hearing, so I'm going to grant the order of possession to the landlord. That's wrong. They can't do that. And this case says that. So MBB basically dealt with Rule 7.3 of the RTB Rules of Procedure. So these rules empower an arbitrator to dismiss an application when a party failed to attend the hearing. But the arbitrator still has to make a finding whether or not the statutory criteria for an eviction, and I didn't mention that this was an eviction, that the statutory criteria of an eviction is met, and that the landlord had met their burden to prove that those criteria were met. Court said that Rule 7.3 of the RTB Rules of Procedure does not empower an arbitrator to dismiss an application to cancel a notice to end tenancy without considering whether the statutory criteria to end the tenancy have been met. It is insufficient to dismiss the application solely on the grounds that an applicant did not attend the hearing. So arbitrators have to make the finding. They can conduct the hearing without the tenant or without whatever party, but they have to make a finding, especially in the instance of notices to end tenancy. They have to make that finding as to whether or not the landlord met their burden of proving that they had met the statutory criteria to end the tenancy. Now, the RTB tells us that they are aware of judicial review decisions and that they do make them available and go over them with their arbitrators, but I can tell you, since this decision, I have certainly seen more decisions from the RTB that are dismissing tenants' applications to cancel notices just on the basis that the person did not attend, failing to undertake an analysis to determine whether or not the statutory criteria has been met. So this continues to happen, but we do have this case. So it's not fatal to a tenant if they don't attend the hearing, because the arbitrators are still making these bad decisions where they're just dismissing it on that basis that they didn't attend. So keep getting behind here. Okay, so this case, Schuld and New, and this is a case involving tenants' compensation. So in this case, the landlord gave a notice to end tenancy to move in a close family member into the unit. But what they ultimately did was demolish the unit. So they never moved in a close family member. They got the tenant out on that basis that they were moving in a close family member, but then ultimately decided they were going to demolish the unit anyways. So the tenant goes back with an application to receive tenant's compensation. And so the court found that the arbitrator chose to expand the definition of the word occupy in section 49 subsection 3 of the RTA, which is the close family member moving in provision, so that it encompassed section 49.6 of the Residential Tenancy Act, and that's the demolition provision. This interpretation is not in the proper legal context. So the arbitrator basically said, occupy doesn't mean reside. Occupy doesn't say you have to live there, so it's fine that you demolished the unit. It was fine. You were able to do that. Tenant, you're not entitled to tenant's compensation because ultimately they did what they said they were going to do. Occupy does not require them to move in. So this case actually says that occupy does actually mean reside. And this case has also been entrenched in Policy Guideline 2A, which is the ending of tenancy for occupancy by landlord, purchaser, or close family member. And it says in the policy itself, references this decision and says that this case stands for the proposition that occupy means reside. So this policy guideline, this decision can be used anytime you're needing to argue whether or not occupy means reside or not, because now we have clarification that it does in fact mean reside. So this is a case, Suri and Vahra, and this deals with the use of an interpreter. And so it's always a bit tricky when parties have interpreters that are family members. They may not have the best proficiency in that language, but it's the best a party could do because interpretation services are expensive. The RTB doesn't provide that service, so some folks, all they have is family members to rely on. And this case dealt with that. It was a case where the landlord's testimony was interpreted by his son-in-law. And during the hearing, the tenant raised the issue of bias and that the interpretation was inaccurate. So the tenant argued that the tenant also had spoke the language that the landlord spoke, so they were able to testify to the interpretation not being accurate, and also could tell the arbitrator the level of proficiency of the son-in-law is not very high. And so they raised that during the hearing. Now the court found that and this was a procedural fairness issue. This is what this was argued as. And so the court found that no breach of procedural fairness in a decision of the arbitrator to permit the interpreter to assist the landlord at the hearing in order to make their presentation. So it's fine to get family members. It's fine to have people come and assist with interpretation. There's no requirement that an assistant chosen by the landlord needs to fulfill a specific function or be at arm's length, or that they even have a high level of proficiency in both languages. So interpreter doesn't have to have high proficiency, and they don't have to be at arm's length of the person they're interpreting for. But the judge did say that a denial of procedural fairness occurs where the interpreter's role crossed over to interpreting the landlord's testimony to the arbitrator. So what the interpreter was doing in this situation was not translating, was interpreting. And you have to be concerned about that when there is that connection where there might be bias. Now you have someone that's interpreting, but not only translating, but interpreting in a way that they think is going to be beneficial to the person they're interpreting for. So when that happens, that's a procedural fairness issue. And so the court said specifically, so limited proficiency in Punjabi coupled with his personal relationship to the landlord raises a real question as to whether the evidence upon which the arbitrator relied in making his decision that the landlord acted in good faith was an accurate interpretation of the landlord's evidence. And that was the other thing. It was about credibility. It was about whether or not the landlord was acting in good faith. So this was the type of case where, particular attention needs to be paid to what's being translated, who's doing the translation. So if ever you're in a situation where there is an interpreter providing interpretation services to a landlord, this is something that you can challenge in the hearing. And it's something that you would probably need to challenge at that level for it to be able to move on to judicial review, because you can't raise an issue on judicial review that's not raised in the decision or not part of the record before the RTB. So that's why it's important to just raise these things then. If they're popping into your head, raise them, because again, if they're not raised at that point, you can't raise them later on judicial review. So the last case I'm going to talk about is, I keep getting behind, my apologies, is a case called Marchall and Pohl, and this is a 2019 BC Supreme Court case, and this deals with adequacy of reasons. And prior to Marchall and Pohl, there was a really great decision that Amber was actually co-counsel on. It's called Lavender and First United. This is a really important case because prior to Lavender, adequacy of reasons was not at all ever considered a ground for judicial review. It's still not technically a ground of judicial review, but judges wouldn't even touch it. They would not go into the realm of the reasons of the arbitrator inadequate or slim, and I'm sure we've all seen our fair share of really bad decisions that don't actually give reasons or state what the evidence they're relying on is. So Lavender helps to kind of swing that pendulum back to judges starting to consider this issue of reasons issued by the RTB. And so Marchall and Pohl is a more recent decision because Lavender was 2015. Yeah, so Lavender is a few years old now, but Marchall and Pohl just is recent, and it is, the judge in that case did consider inadequacy of reasons there. So I think that's a good sign that we're still like on that upswing towards adequacy of reasons being considered by judges on judicial review. So in this case, this was a case where the tenant was given a 1-month notice for cause for significantly disturbing other tenants. Now, the types of incidents described were things like, oh, he doesn't hold the door for me, or, he didn't say hello to me. So whether or not that rises to the level of significant, that was for the arbitrator to decide. Nonetheless, this case was successful because the court did find that the reasons were not adequate, and specifically the court said that the arbitrator summarized the evidence and submissions of the parties but makes no findings of facts about which incidents actually occurred beyond the general statement that there were multiple incidents. So the arbitrator doesn't specify this incident or that incident, just there were multiple incidents. The arbitrator does not address the petitioner's explanation and denial of some of the complaints or explain why the evidence of the landlord was apparently preferred. That's another thing. If a arbitrator is preferring a landlord's evidence to a tenant's evidence, they have to explain why. You have to know why someone else's evidence is preferred to yours. So that's part of the adequacy of reasons test. And the judge also went on to say that the arbitrator does not explain which incidents, either individually or cumulatively, met the statutory standard of significant interference or an unreasonable disturbance. So that's what the case won on. The issue of whether or not the incidents rose to the level of significant was not considered. That goes to weight, and weight is not considered by judges on judicial review. So adequacy of reasons won the day. So good sign. Thanks to Lavender, we can continue to make these arguments on judicial review, and Marchall and Pohl is the most recent example of that. So that's it for case law updates. Are there any further questions? I think we got about 5 more minutes.
Would you have to raise during the hearing that you feel the arbitrator is accepting the landlord's evidence more? And is that something then you could take to the judicial review? Because we do have a landlord that has a couple of buildings, and we've had tenancy hearings where they've seemed to use the same evidence against multiple tenants, but the arbitrator does seem to err on the side of the landlord. So I'm just wondering, could you clarify how you could use this argument to get to the judicial review stage?
Right. So the inadequacy of reasons argument is more about not so much what happens or what's raised in the hearing. This is more just focused on the decision itself. So if in the decision it'll just say, like, I prefer the landlord's testimony and that's it, then you're probably looking at a potential issue of inadequacy of reasons. Certainly I'm thinking about when you're in the hearing. At that point, you don't know what the reasons are going to be. So you can't really, there's not much I think you can really do at that stage. The best thing is always just raise every argument, every instance where you think the arbitrator might be biased, because then you can have that addressed. So if you felt that there was a bias there, for the landlord, bias is very difficult to prove, but you would want to raise that there is maybe some bias at that stage for it to be considered on judicial review. But basically, inadequacy of reasons, again, not much you can do in the hearing itself, because it's all about the reasons, and we don't know what the reasons are going to be during the hearing. So it's really just applicable to after you get that decision. I don't know, anyone else, do you have anything to add to that?
Yeah, I was just gonna say, I mean, that scenario lends itself to scrutinizing the reasons carefully, I think, because it sounds like in that scenario, it might be the landlord's just recycling old information and like old arguments, and the arbitrator has to grapple with the evidence that's before them, and they have to explain why they've preferred that evidence. So it seems like a red flag in this scenario if it's kind of like this pattern that you're seeing. So it's probably worth raising with someone like Danielle at CLAS if you're seeing that. And then you could, I'm assuming you would assess the reasons to see if the RTB has adequately explained why they've preferred the landlord's evidence in that case. Yeah.
And I mean, again, for most of us who do this work, For most of us who do this work, we know that there's just an inherent bias, and the RTB tends to most often go in favor of landlords. I mean, the act itself is not fair towards tenants, and the RTB in their decision making doesn't appear to be fair towards tenants and seems to have a preference for landlord's evidence. Not uncommon to see these decisions where it just says, I prefer the landlord's evidence, but we have no idea why. Why are you preferring the landlord's evidence to the tenants right now when they're conflicting? So, yeah. It does go to credibility, absolutely. Because if there's a conflict, especially when there's a conflict in the evidence, landlord saying one thing, tenant saying the other, you absolutely, as a decision maker, need to clarify why you're choosing one side over the other. If there's no conflict, if one party is just sort of accepting it and not really fighting it, then, they should still say why they buy the landlord's evidence, but especially when there's a conflicting testimony, they should absolutely be explaining why they're choosing one over the other, because that lends itself to that inherent bias that, the decision makers tend to often go in favor of landlords to tenants, especially when we're dealing with these subjective type of issues, right? Whether or not something's significant enough to warrant an eviction, or that's especially tricky. Any other questions?
Okay, maybe I'm confused, but I thought it was the role of the arbitrator to determine credibility. So I have had decisions where, in the absence of corroborating evidence on either side, and one party says one and the other party says the other, I know the onus should be on, an eviction, I'm talking, these are invariably the situations, the onus should be on the landlord. But often, like I see the decision, and the decision says, I find the landlord's testimony was more credible. And I actually thought that was okay, that was within the purview of the arbitrator. Are you saying it's not?
No, credibility is absolutely in the purview of the arbitrator, and a judge won't redecide who to believe and not to believe. A judge isn't going to make those judgment calls about what the arbitrator found as far as credibility goes.
Okay, so you're distinguishing that from adequacy of reasons.
Just exactly. So they just have to explain why. Like, they get to make that finding, but they have to explain why one party is more credible than the other. And if they don't, then we're looking at an adequacy of reason issue. But if they do, we can't challenge that, because a judge won't decide who to believe and who not to believe. That's already been done by the decision maker of the first instance, which is the arbitrator. So, yeah. Okay, guess that's it. Thank you all for coming.